Good evening, everyone, and welcome to the Beverly Hills Bar Association webinar entitled Effective Mediation Practices, Thoughts and Observations of Selected Mediators. This webinar is presented by the Labor and Employment section of the Beverly Hills Bar Association, which is chaired by Nazgul Hashemi, and the co-chair is Andy Fields, and I want to take this opportunity to thank Andy for her assistance in organizing the program. And also I'd like to extend my thanks, and I think the thanks of all the panel, to Kathleen Zapata and Leslie Aguirre of the Beverly Hills Bar for their assistance. Before we begin, we have a few housekeeping matters to which I must attend, but I will do so expeditiously because we have three very accomplished panelists, and I want to get us to the program as soon as possible. You will receive your MCLE certificate shortly after the program, and your certificate will be also stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that you will receive along with your certificate. The program will be available in a couple of days on BHBA On Demand, which is the Beverly Hills Bar's newest member benefit, presented by Lawyers Mutual Insurance Company. We intend to take questions towards the end of the program, so please type any questions you may have in the question and answer place, the button there on your screen. Try to keep it brief so we can get to as many questions as possible. Now, I'm going to introduce the speakers, but I'm going to introduce each of them briefly. If I recited all of their experience, qualifications, and accomplishments, it would probably consume half of the time allotted for the program. However, their full bios, and mine for that matter, are included in the materials that you probably have received by now or will receive shortly after the program. So feel free to consult those bios if you wish. And in the materials also is an article which I believe covers much of what we hope to address this evening. The Honorable Gail Andler retired from the Orange County Superior Court after 22 years on the bench. Her last 10 years were spent in the Civil Complex panel, where she presided over a variety of employment disputes, including wrongful termination, discrimination, class actions, and PAGA matters. Upon her retirement in January 2017, she joined JAMS. She has a national practice mediating employment disputes in such varied industries as entertainment, sports, hospitality, technology, insurance, cannabis, and healthcare. Judge Andler is frequently selected by counsel and appointed by the courts to allocate large settlements in sexual abuse and mass tort matters. Welcome, Judge Andler. Ann Kotlarski is a mediator who's been with Judicate West since 2016. She was a successful employment and business and commercial trial lawyer for 30 years. And in those 3 decades, as an associate and as a partner, she tried, arbitrated, and mediated hundreds of cases and implemented many in-house ADR programs for clients. She earned the respect of her clients, colleagues, and opposing counsel for her philosophy of limited discovery with a goal towards early resolution. As a result, she was often asked to give presentations in conflict avoidance and to serve as a neutral fact finder. Her mediation practice includes business matters, commercial matters, employment cases, government and public agency matters, and tort matters. Welcome, Ann.
Welcome. Thank you.
Eve Wagner joined Signature Resolution in 2019 as a mediator and arbitrator. She has mediated and arbitrated hundreds of cases involving employment, entertainment, business, and real estate matters. Previously, she co-founded a successful litigation boutique and practiced extensively in federal and state courts, as well as alternative dispute resolution forums. She litigated both plaintiff and defense side employment cases, as well as both sides of entertainment, business, and real estate matters. She represented individuals as well as small to large publicly traded corporations in various industries, including entertainment, real estate, finance, retail, hospitality, and manufacturing. More than 18 years ago, Ms. Wagner expanded her litigation practice to include mediation and arbitration. Since then, she has resolved hundreds of cases involving a wide variety of disputes, ranging from single to multi-party complex matters involving employment, civil rights, the Unruh Act, class actions, PAGA claims, entertainment, intellectual property, legal malpractice, fee disputes, premises liability, and personal injury. Welcome, Eve.
Thank you.
My name is Peter Marx, and I will serve as your moderator this evening, and I'm a longtime mediator with Alternative Resolution Centers, commonly known as ARC or ARC. My mediation practice focuses primarily on employment disputes, business disputes, and entertainment matters. But over the years, I've mediated in a variety of subject areas such as real property, construction, legal malpractice, personal injury, civil rights, and family disputes. Now, let's get on with the program. And let's begin at the beginning, which is preparation, specifically preparation not only of counsel, but of the client, which is perhaps more important. And Kotlarski, please give us your views on this subject.
Well, I have a lot of them. Okay. Preparation is really the key to having a successful mediation, just as it is in litigation. So my philosophy as a trial lawyer was whoever figures out the case in the first 90 days from the time that claim hits your desk, whether it's a pre-litigation demand or an arbitration claim or a lawsuit filed in state or federal court, that really sets up your opportunity for success. It's not the last 90 days before trial or what have you. It's the first 90. And that means gathering the documents, witnesses, any other evidence that you can get out there from third parties. It is really key in mediation because mediation has now become our new kind of trial form. And that was particularly true, I think, before we went into the pandemic and once we went into it, when the courts were closed. And people were really looking to mediation as to help resolve a number of disputes. And sometimes I found myself resolving discovery disputes to try to get cases done. But one of the big things is being prepared. So from a lawyer's perspective, I look at if you do thoughtful, strategic, well-planned preparation, it will enhance your performance in the mediation arena, whether you are representing the plaintiff or the defendant. For the plaintiff, inevitably, it can increase the chance of success on a payout. For the defense, it can decrease how much you pay out. It depends, and sometimes I see both sides well prepared, but something I've shared with a number of my colleagues is particularly in the last 18 months or so, I've seen a marked decrease in preparation.
That's interesting.
So I'd like to give some practical pointers for what to do, because certainly nobody wants their mediator to dial it in. And I think when I sit down as a mediator, I want to have as much information as possible, but distilled in a concise and thoughtful way. So the first thing I'm going to start with are briefs. Keep them brief, okay? If there's a page limit, respect the page limit. If you can't, let the mediator know why, because we have to schedule time to make sure that works. In terms of writing a brief, I think what's really important is to tell your story. Whether it's not they did this, they did that, write your opening statement. Write your opening statement, whether you would be in an arbitration or whether you would be in trial. And that means stick to the facts. Tell your story. You should have a theme, just like you would in a trial. And that theme needs to encompass the good facts, the bad facts, and the ugly facts. You need to be prepared to address it all, because a mediator who's really working with both sides is going to be addressing those issues in both rooms. So I think factually, you need to lay things out. You need to lay them out not only in a way that makes sense thematically, but in many cases, and you see this in employment matters all the time, that old adage, timing is everything. So setting that out with a timeline. I like to see a timeline sometimes as an exhibit A, with the dates, a brief description of the event correlating to that date, not a paragraph, a brief description, and then keyed to the evidence. So you may tell me, go look at exhibit B or C or what have you, and I'll address exhibits in a minute. But I think that's very important. Things I do not like to see in briefs, adjectives. Okay, I have a no adjective rule because adjectives really don't tell you anything. They are not a fact. Another thing we don't need in a brief, opinions and conclusions. We can reach those ourselves, okay? And name calling. God, I hate it when I see name calling. That doesn't help move the ball. But what helps move the ball is evidence, okay? I think it's also very important in your briefs to identify openly the challenges that you see in your room, perhaps that are evidentiary, and how you're going to address those, how you would address those if the case were to proceed, and the challenges your opponent faces, and how you're gonna, get them. But again, analyzing them through a factual perspective. I think one thing most mediators do not need, unless it's a new legal issue or something that's very nuanced, or your case should be viewed differently under the particular legal principle, is a recitation of the law. There is nothing more useless than getting a regurgitated summary judgment motion or an opposition to summary judgment. I think lawyers are savvy. They're paying mediators to know the law. So you really don't need to put it in there unless it's something novel or something nuanced with that. Before I leave the topic of briefs, do submit them timely. And if you can't, let your mediator know that you can't. I'm fine if people are going to miss a deadline. Just let me know, because I have to shuffle my schedule to make sure, and I'm sure Judge Andler does this, and I'm sure Eve Wagner does it. You got to move things around to make sure everybody gets enough time from the mediator to prepare for those things.
You have any thoughts about serving the briefs on the other side?
I think you should. And so if you're concerned about confidential information, and my briefing guidelines, which I send to counsel usually a week or two in advance of the mediation, encourage people to exchange. I will tell you, I see more plaintiff's counsel exchange than I do defense counsel. I don't know why. I think it's got to be, sometimes that's more client driven than anything else from my past experience. But if you've got something you don't want the other side to see, just create a separate brief for exchange. Take that information out and exchange a brief that you're comfortable with the other side. I think that really helps, because we spend a lot of time, in the early sessions educating back and forth. I think it also helps, particularly when the defendant exchanges with the plaintiff, so the plaintiff's counsel can work with the plaintiff and explain the other side, because you may not be dealing with a sophisticated party. So I think that's a good point. Another thing that I see are declarations. I like to see declarations, but again, not dialed in. So what do I mean about that? Declarations that clearly look like a lawyer wrote them, and there's no way in heck a witness could ever say those things on the stand, are not helpful. They need to be, in the witness's own words. I see many, many declarations where personal knowledge is not established. There's no foundation. So if there's no foundation, that doesn't help me. Opinions and conclusions are completely irrelevant in a declaration. The fact that a coworker thought another coworker was great, who cares? If you're an expert, I care about your opinion and your conclusion. If you're a witness, I want to know what you heard, what you saw, what you observed. And I think the other thing that I see is a lack of people actually considering what's admissible and not admissible. But if you do those things, I think it's very helpful. If you're on an employment case, if you're the plaintiff, I think getting the declaration from a current employee is difficult, but that's great evidence. If you are an employer, getting a former employee who doesn't have a dog in the fight because they don't have a paycheck, great. If you're on either side and you get a third party, hooray for you. Okay. So I think that those are great. One of the other things I like to see in session as part of preparation is witnesses. And that's what I think is a plus with Zoom. Because now nobody can say, oh, and they're in Riverside, they can't drive 19 hours to downtown Los Angeles. I just say, flip them the link. Do they have a phone? I'd like to talk to them. I'd like to see them. And I do find that helps move the needle. And I do have counsel on both sides of the bench, the table, who will do that. So I think people should consider presentation of witnesses. Just give your mediator a heads up that you're going to do that, so we can plan for it. I think the other thing that's important in terms of preparation are pre-mediation phone calls. I am a big, big proponent of those. If your mediator doesn't offer them, what I used to do back in the day was I'd call up or email the mediator and say, hey, I'd like a call with you, because it's a great way to start the process. And I think it's a great way for counsel to have a private conversation outside the presence of their client to discuss whatever concerns they may have, first about their client,
Yes.
how they like to negotiate, whether they're going to want to be able to talk to me separately during the negotiations. If they're exchanging briefs, certain things that they don't necessarily want the other side to know yet, and sensitivities of their client. And it doesn't matter if you represent a single plaintiff or an entity. All clients have touchy areas that, do not go zones. So I want to know your do not go zone. It's also a really good time for me to vet out how much crap people are giving me on the insurance issue.
Very good.
My least favorite phrase is when I say, counsel, is there insurance in the case? And how do they respond? It's not at play. What the heck does that mean?
Do they actually say that? I've never heard anybody say it.
It's not at play. I'm like, I'm not talking about the NFL people here. Do you or do you not have a policy?
I'm sure we've all had cases where you bring in you have two mediations going at once, one on liability and one on coverage.
Right. And that's why I think it's a good thing to do the pre-mediation calls, because lots of times that issue is not in the brief. But if you have that call, and if your mediator offers calls, please take them, because that's the perfect time for the mediator to start looking at that stuff and trying to figure out what kind of issues they're going to be. And also, frequently plaintiffs will want to know, is the adjuster going to be there?
Mhm.
And I am seeing more adjusters now participate in mediation because of Zoom.
Well, also, even before that, it got to the point where in many cases, I found the adjusters were driving the train. Counsel
but
was
not there.
Well, we would
Not
get them there now by phone or some way. Yes, but that's an important point. That's helpful.
Yeah. So I think those are the big things. People really need to think that mediation is probably one of the biggest events in your case. I mean, in a lot of ways, it superseded summary judgment, which can be very, very difficult to get in many cases. And, it is kind of the big event for your client or clients in terms of what do we do before we expend more money, time, effort, and emotion. So I'm a big, big proponent of preparation, as you can tell.
Yes, and thank you very much. It's very helpful. Eve, can you give us an indication of some particular concerns which may facilitate or obstruct the process of mediation?
So one of the most important parts of mediation, of course, is where the initial offer is and the response. So I call that anchoring, because it's the first thing that parties react to in a mediation. And we've seen a trend, and a lot of us mediators have been talking about this over the last several years, where we're getting multi-seven-figure demands. And in response to that, we're getting the classic $5,000 response. There's certainly many, many cases where a seven-figure demand is warranted, but there are many cases where it is not. And what's happening is when defense counsel hear it, particularly where the value of the case doesn't warrant it, they tune out. And when you go into the room with a seven-figure demand in a case where they valued it, let's say in the 5 figures, and maybe it should settle somewhere in the low 6, let's just say it's one of those types of cases, what happens is you get an immediate negative reaction. The client shuts down, the adjuster's like, oh, scoffing, and it takes a lot longer for us to get them to the table. Their knee-jerk reaction is, this is a waste of time, let's go home. I wish they had communicated this because we never would have come to mediation. And so we spent a lot of time with this. Similarly, on the defense side, when a plaintiff's demand is reasonable, or even if it's unreasonable to them, and their reaction is it's $5,000 every time, no matter what the case is, no matter what the demand was, or what the merits are. So a lot of time should be spent on these anchor points. The other thing, here's an example. I had a case that I mediated several months ago where a fairly young plaintiff's lawyer came in and his opening demand was over $2 million. And I was shocked because it was not a particularly strong case. So I asked him, are you sure you want to start at $2 million? Because I'm looking at these facts, what warrants it? Help me go into the other room and explain why that demand makes some sense. He didn't. We went through the course of the day. I kept the parties there. The case settled for something like $60,000. The reaction of the defense lawyer was, well, that guy's got no credibility. So that was not a effective strategy. So we see this again, think about where you want to start and make it, there's nothing wrong with being aggressive, but be realistic. Then you get the next phase, of course, is after we get through what we often refer to as the insult rounds, then we're into the negotiation. Another trend that we see is no matter what the defense does, plaintiff comes back at either I'm going to match it, I'm going to double it, or I'm going to triple it. Doesn't matter what's happening in the mediation, that's what we're doing. So let's say you started at 1.5 million and they think, oh my God, that's ridiculous. There's no damages in this case, or there's some other problem with the case. They come back at 2,500 or 3,000 or 5,000. And the response is to come down 5,000 or 10,000. We're stuck. So us mediators then have to get over that hurdle, which sometimes can take quite a bit of time. And occasionally the other side's gone and it's a missed opportunity. So those moves should reflect what's happening in the mediation. So for example, I'm getting this comment a lot. Facts don't matter anymore. We come to mediation, we're loaded to bear with facts, and the other side won't consider it. And this is on both sides. So for example, show up at mediation, plaintiff has 6 Me Too declarations. It would have been nice if they shared that beforehand so that the other side could evaluate it. That goes to Anne's comment about preparation and also setting expectations. But let's just say you've got these declarations, you just got them, they're great. Even these witnesses, the mediator is allowed to talk to some of those witnesses. So we can actually question the witness and find out, is this a rote declaration or is there meat to this? And we go in and we explain that to the other side and they don't want to hear it. They won't factor in new facts. Conversely, I've had mediations where I've got documents and I don't know why they weren't produced yet. Maybe it's very early on in the case, but let's say there was a request for termination and a final paycheck. There was a holiday and it took a couple days. Meanwhile, in between that request, plaintiff comes in and says, I'm pregnant. And it's a pregnancy discrimination case. But wait a minute, the termination decision was made before anyone knew. And we have confirmation of exactly when she told the person that she was pregnant. So it can't be pregnancy discrimination, it might be something else, but it wasn't pregnancy discrimination. That's a fact that should get factored into your negotiation. And what we're seeing sometimes is it's not. And what happens when that happens is the other side shuts down and says, well, facts don't matter. Why are we here? This is a waste of time. So those are really important things. Mediation should be flexible. People need to listen and actually evaluate what is happening during the course of the mediation. In terms of the preparation, it's really helpful for those of us mediators that like to get into the weeds to have some of the evidence. So I've had cases where somebody's alleging, after they complained, their hours went down. It's early in the case, so we don't actually have the time records yet. So the defense says, that's ridiculous. They still had exactly the same hours. Okay, well, you have possession of the time records. Do you have them? No. Well, could you go get them? Because if that's true, that's going to hinder, put a dent on that retaliation claim. So we spend a long time, we'll go pull the records and 3 hours go by and maybe the records bear that out, maybe they don't. But those are the kinds of things, start thinking, what are the arguments that the other side is making and what evidence do I have that I can give to the mediator to use during the course of the day to help that mediator bring the number up or down.
That's the same in wage and hour cases where plaintiff comes in
absolutely
without an estimate of their hours. And I'm thinking, why are you here? But then we spend another hour trying to get a rough idea of what's at stake, and then we go from there.
Or the sample data is too small that the defendant has provided, or the defense is going to come in and say, oh, I don't have any money. How often have we all heard that one?
Yeah, so
if you're going to claim it, you need to let somebody know you're going to claim it, and you need to be prepared to show it. You can't just claim it. So that also puts a dent in the mediation, and sometimes that ends the day. And then we have to have a follow-up, many
Yes.
follow-up sessions after financial information is exchanged. But why not tell the other side that? Bracketing, I wanted to talk about that a little because that's a negotiation tactic that we often use to get the numbers closer. One of the really important things about bracketing is to make sure your mediator knows, and your mediator should ask, but what are you intending to convey by your bracket? Is this really a midpoint? So
Yeah.
when you say, okay, if you go to 100, I'll go to 900, probably not a midpoint bracket, but the other side needs to understand, no, you're serious. You mean if you go to 100, we'll come down to 900. Or are you saying, we'll come to, if you come to 500, we'll come to 900, and you're looking at the midpoint. Really, really important that that gets communicated. But brackets can be a very effective tool as long as everybody's playing by the same rules, or at least understands what rule the other side is playing by. Know whether the other side is a competitive or cooperative negotiator. What do I mean by that? You can research and talk to people to kind of get some idea of what opposing counsel is like. So let's say a cooperative negotiator might start at 25,000, and you think, oh my God, they're at 25,000 as their opening. That's fantastic. They're probably going to go way up. Well, maybe they're just a cooperative negotiator and they only want to make 3 moves, 25 each, and they're going to stop at 75. Versus competitive negotiators where they're, I'm only going to give you 5,000 when really they've got 500,000. So it's important to kind of know who you're negotiating against. Let me think. What other things do we want to cover? Providing a pre-mediation demand.
Oh,
I'll
okay.
just talk about that really quickly too. That's very helpful, particularly where there are multiple decision makers or insurance. So if there's insurance, what typically happens, as you know, is the defense side is going to do an evaluation. They're going to say what the demand is or where they think the demand is going to come in. They're probably going to get some settlement authority. Of course, that can change during the course of the day. But having that pre-mediation demand helps that process immensely. If you're going to increase your demand at the mediation, so sometimes you've sent a demand letter and you've said, in the event you we'll settle for $500,000, let's just say. And then you come to mediation 6 months later and you're at 3 million. What happened? So there has to be, if you didn't tell them you were going to change that. And I've even seen it, and this is where it really becomes a problem, when it's a month and a half later. No depositions, nothing changed. It's just a month and a half later. There has to be a reason that we can articulate in the other room, because that sets us back, I don't know, an hour, 2 hours, trying to get everybody back to the table because they want to leave. So think about if you're going to increase that demand, why? Was there some new testimony? It's not just the passage of time, something else. I think I was going to talk about joint sessions briefly. So back in the day, and since I'm old, we always did joint sessions. What we found with joint sessions a lot of times were both sides would just get really angry at each other and they'd go back to their respective rooms, and then we'd spend, I don't know, 2 hours trying to calm everybody down. And the mediations, I don't know how many people remember the good old days where we were mediating till 9, 10, midnight. They took a lot longer. I don't do joint sessions initially. I occasionally will do a joint session in varying forms. So let's say somewhere in the course of the mediation, we're just at loggerheads and we're not getting anywhere. And I've tried all my tricks in the trade and we're still not getting anywhere. I might suggest, let's put counsel together with me. Let's have a dialogue. Why are you both so entrenched? Maybe you need to hear it from each other to see the passion that both sides have about their case. Sometimes if it's really early and the defense has never met the plaintiff, or there's a key witness like the harasser or somebody else that plaintiff's counsel has never met because there's been no depositions, it might make sense to have like a little Zoom meet and greet where you're not examining anybody, or questioning them, but at least you get a sense of who they are and maybe they'll say a few words or something like that. That's another thing I've done. So it really varies on the mediation. Every mediation is different. So flexibility is really the most important part.
Any thoughts about preparing settlement agreements in advance?
Please, please, let me give you an example of one of my worst nightmares. So I had a case that I mediated, very difficult, very emotional plaintiff, wavered back and forth. I kept telling defense counsel, if we settle this case, please have your settlement agreement ready. And they kept saying, we're going to, and I go in, is it done? It's done. All we got to do is put in the number. Like, fantastic. Another hour goes by, we settle. So I go back in defense room. They know the number. So did you plug in the number? Are you hitting send? Well, we just have to review it one more time. An hour and 55 minutes later,
Whoa.
Plaintiff disconnected from Zoom. Could have walked out if we were in person. He had it. And I kept going in, is it done? Please tell me it's done. It was not done. It didn't get done until like 2 hours and 15 minutes later. That case did not settle for another 9 months.
You're telling us it took an hour and 55 minutes for counsel to review the agreement he or she had prepared?
And said was finished. No, it took 2 hours and 15 minutes. He deserted after an hour and 55 minutes and we could not get him back. So
You know what?
9 months later, the case settled. But the point is, and many times it takes 2-3 hours to get the draft. It shouldn't, because we have a plaintiff who's sitting in there stewing, thinking, should I really have settled this case? Or vice versa, sometimes in the wage and hour context, a defendant who's sitting there going, why am I agreeing to pay this much money? Forget it, never mind. So it's great if they're exchanged in advance. I know a lot of people don't like to do it. They feel like it jinxes the process or sends the wrong message. I don't think it does. But if you feel that way, just have a form ready that's been vetted by the client, and all that's missing is the amount.
Peter, I handle that in my pre-mediation calls. I start talking to them about my experiences and my preferences with them. And I say that I know that it may take a while for us to get to a long form agreement. Typically, you'll do that offline, but I want you to start thinking about the language you want in a term sheet so that you come prepared with that language. And if there are particular provisions you're going to want to see, share them in advance. But what I don't want to happen based on my experience is that you get to the end, you have a deal, and somebody gives a client a long form agreement with all that legalese in it. And of course, the client thinks they're the smartest person in the room. They're not going to admit that they don't understand what's in the agreement. And now all of a sudden you have a problem. So I think that getting back to Ann's comments about preparation, talking about the settlement agreement should be part of the beginning of the process where you start preparing counsel, and they start preparing the client, and you prepare yourself for what's the end going to look like.
You raised an interesting point, because if it is a very complicated agreement that perhaps it's not possible to complete at the mediation, I always tell people, don't leave without signing something. Make a deal memo or something, sign it and put language in there that says, well, we're going to prepare a long form agreement, but until that's prepared, this document is final and binding, so that you don't avoid that problem of the thing falling apart 2 days later.
I do try and get a long form done at
Yes.
the conclusion of the mediation, because otherwise what happens is it drags out, and often we get pulled back in because they're arguing about terms, but it drags out when the plaintiff is actually getting paid.
Details like that.
I really do try. And then while we're there, the nice thing is if you're doing the long form and there's a fight over certain terms, we can put plaintiff's counsel together with us in the room, put the document on the screen, work it out right there, get it done, explain it to plaintiff, explain it to the defendant, and get it signed. That way it's signed, sealed, and delivered, and you're done.
Get home for dinner. Okay, thank you, Eve. That was very helpful. Judge Andler, can you address certain other matters which are important to the process, to having it move along smoothly?
Sure. Going back to what Ann said, and talking again about preparation, I think the pre-mediation calls are important, not only for counsel to be prepared and the client to be prepared, but also for me to be prepared. So I use the pre-mediation calls for counsel to also prepare me about what I call the secret stuff, the stuff that doesn't make it into the brief. Tell me if you have client control issues. Tell me if there are sensitive financial issues. Tell me if the company has a sale pending or impending. Well, I don't want to hear that when we're in there for the first time. Is the person who's going to be at the table the person who owns the problem? Did they create the problem and now all of a sudden they're going to be defensive and they're actually representing the company at the same time? So I want to talk about logistics during the secret stuff call. I don't repeat the information I've learned when I'm in the room with their client. I promise them that confidentiality. I want to know if there's a problem with dynamics between counsel. I talked to them about style, and we all know that there's a spectrum. You've got the mediators that on the one end come in the first 15 minutes and tell you that you're going down in flames. And on the other end of the spectrum, you have somebody who tells war stories for 7.5 hours. I tell them that my style is neither one of those, but I tend to move more quickly. I tend to have initially facilitative and then move into evaluative if that's what the counsel want. But we talk about, what do you want? What are you looking for here? So I think that if this all is part of your preparation, talking about DocuSign, are we going to use it? Talking about, do you need information from the other side that you still haven't gotten in order to evaluate your exposure? What can I help you get from the other side before we sit down? And then I talk about sharing briefs. So part of this is preparing me. Part of it is also letting the attorneys know what my style is. I also want to know if they have any time constraints. Besides who will be there, do we have various time zones? Am I going to find a situation where we're going to be dealing with somebody in the UK and I don't know about it in advance? And you see somebody trying to hold up their eyelids with toothpicks as we continue on. I want to know if there is a mediation within the mediation for things like not only insurance coverage issues, but are there indemnity claims? Is there somebody else that we need to have at the table? And if so, maybe we even want to explore a co-mediation situation where in multi-parties, you can have two people working effectively on the bigger cases with lots of moving parts in that regard. When we have multiple defendants, I want to talk about in advance. Are their contributions going to be towards a global, or are you going to try and get out separately? Is there any reason not to disclose what people are putting in to the pot? So talking about these things in advance saves valuable time during the session itself. If I'm going to be doing it remotely, and we do a lot of those remotely, I'll talk about how I intend to use the platform and kind of go over that with them. If I'm doing it in person, and I do a lot of them in person these days, we'll talk about the logistics for the in-person session. On the joint session, individual session. Oh, and by the way, about briefs, I don't have any preferences. I want a brief, but I don't care how long they make it. I'm going to read everything they give me. I don't care if there's argument in it. I don't care if they cut and paste from a summary judgment motion. I let the attorneys pretty much control that process, and I go through it and get what I need out of it. But I do encourage them to share it. And if they're going to share it, I ask them to consider not making it a document that contains only arguments, so that it will be only entrench the other side. On joint sessions versus individual sessions, I let counsel know that generally my preference in California mediations is to go into individual sessions, but when I'm mediating on the East Coast or the Midwest, they still do a lot of joint sessions. So we talk about that. But typically in the California mediations, I would only do a joint session if somebody tells me it's going to help us be more effective. Is there going to be an expert presentation, or is there some other reason that maybe I don't know about where we ought to have people together? And if counsel wants to use breakout rooms to talk to the other counsel, I certainly have no problem with that. And that can be very helpful, especially towards the end of the process. In terms of what is most important to the process, though, I think it's really the mediator building trust and rapport. And the way that you do that is with your preparation. Read everything they give you. During the discussion, reference what you've read. So not only the attorney, but the client knows you've bothered to read what they've given to you. And I think it's important to acknowledge the hard work that went into it by their lawyer. Let the client know that you feel well prepared for the task ahead because of the hard work that's been done by their attorneys. I think that, you know, if an attorney gives you a comprehensive and well-written brief, I think it's important to let the client know. Also let the client know, and this is part of trust, respect, and engagement, that you're going to be talking directly to the lawyer as though perhaps they'll feel like you don't acknowledge that they're even in the room. I want them to know that that's not meant as a sign of disrespect. It just helps to expedite things, but I tell the client that their voice is important, and if they want to take 10 minutes and tell me what's most important from their perspective, to go ahead and let me know. So that way it builds the engagement, their voice can be heard. And it's very important to keep promises you make about confidentiality. If you're going to tell the room your style is that I can talk about anything, and unless you tell me to keep it in this room only, if you flag it for me, I won't share it. Don't share it. You know, breaching that confidentiality as a mediator goes against every bit of our ethos, and it's just it's beyond disrespectful. It's unethical, and you shouldn't be doing it. So don't hint at information you've learned when you've promised you're going to keep those. Gee, I could go here, or maybe I'll do there. You know, you don't even hint at that. I think that I've covered the issues that we had pre-discussed about what makes it effective and what makes it ineffective. If it's a Zoom mediation, I've already said, make sure you know about the technology, exchange phone numbers, have a back line. We could do a whole session on doing an effective Zoom mediation and talking about how you're going to use your breakout rooms and how you're going to document it. I have some comments on mediators' proposals, if you want to get into that, Peter.
Yes, can I just make one comment about
Sure.
Zoom mediations? I have found that sometimes the client in the Zoom setup is seated far away from the camera, and they become distanced, literally and figuratively, and sometimes disengaged. And one mediator, a colleague of mine, has suggested that the client have his or her own camera, sit in front of their own laptop or computer or whatever. Without going into a lot of detail, my experience is when you have a recalcitrant client or someone who's resistant or unrealistic, it's much harder for me as the mediator to engage with that person if they're off in a corner on a Zoom. Whereas if they're across from the table from me, I can read body language easier. I can communicate more effectively, and as you say, build trust. So I have mixed feelings about Zoom mediations, although I think the settlement rate, I don't know what your experience is, but is pretty much the same.
Mm-hmm.
That's been mine. Please talk about mediators' proposals. I think that'd be very interesting.
Sure. I only do mediators' proposals when the parties agree to it. I don't march in there and say, here's the number. So, and only when we're at impasse. So I let the process play out. And if the parties are at the point where either they've requested a mediator's proposal or they're at impasse, then we'll talk about the possibility of a mediator's proposal. But I tell them all sides have to agree to it. And then I have a mediator's proposal process that typically does the mediator's proposal while we're still in session. And I put them on what I call a shot clock. I explain this to them. I say, okay, we're at the point where I'm going to do mediator's proposal. It's going to be blind. I explain it to the client if the attorney wants me to. Sometimes they'll tell me they've discussed it, but I'll just reconfirm that their answer is going to be blind. And I'll say, I'm going to come up with a number. It's not an evaluative number. It's not what a jury would give you. It's what I call a get it done number. It's a number at which I think the case can settle based on the information that I have learned from this process. And when I give you the number, by the way, my mediator's proposal is only going to deal with the number. It'll be subject to the usual documentation, usual terms and conditions, and for the most part, I don't include non-monetary provisions in my mediator's proposal. And then I'll give them the number. I say, here's the number, and I'll be back in 10 minutes. And your answer is yes, no, or I need more time. And I do the same thing in the other room. And I do that because in my experience, it's very successful because people are there. You've got the momentum. They're highly motivated. And in most instances, they give you an answer right away. But if somebody has said yes, and the other side has said either I need more time or, well, if I have two yeses, we've got a deal. If I have two, I need more times, or one yes and I need more time, I just figure out from talking to them how much more time they need. And I'll say the mediator's proposal expires, next Tuesday at noon or whatever the appropriate amount of time is. And if it's no, then at least we're still in session, and if somebody wants to keep going, we can keep going. But it's building on the momentum, giving somebody the relief of having it done, in my mind, really weighs in favor of at least giving it a try. and to do it in session. Interestingly, there are places where you can't do a mediator's proposal. I learned this, that if you are in Florida and you are a certified mediator, certified mediators in Florida, certified by the state, cannot do a mediator's proposal because it is considered to be unethical. It's considered to take away from party self-determination. I don't think the way that I do it, or the way that, as we've talked about it, any of the rest of you do it, would be something that takes away from party self-determination, but that's just an orientation that the Florida State Bar apparently has to it. So that's my take on mediator's proposals. There have been times where we didn't get it done in session and we continue post-session with the negotiations back and forth. And then somebody might say, I think we're ready for a mediator's proposal. And then if both sides agree, I'll write it up and I'll send it by email. But I really like to try, at least give it a try while we are in session.
Any thoughts, moving to another topic, because we're surprisingly, the time flies when you're having fun.
Yeah.
Any thoughts on confidentiality issues with particular reference to sexual harassment matters?
Right, sexual abuse, sexual harassment, or claims that are related cannot be documented with a confidentiality agreement in a settlement agreement. In other words, those provisions are void. It voids the settlement agreement under CCP 1001. CCP 1001 prohibits confidentiality agreements for filed civil actions and administrative complaints where they're already proceeding. So a way to get a confidentiality agreement is if you're doing it pre-filing, pre-litigation, then there's still the possibility to do it because that's outside of 1001. And even within CCP 1001, you can still have an agreement that the amount of the settlement will be maintained as confidential. And if the person who is the plaintiff does not want to have their name disclosed, or does not want to have discovery that could lead to their discovering what their identity is, then the settlement agreement can keep those things confidential as well. There's a legislation as of January of this year that expands 1001, the impact of 1001 to cover the other claims by FEHA that are not in the nature of sexual abuse, but are retaliation or discrimination, et cetera, based on FEHA. And so it's called the Silenced No More Act. It was Senate Bill 331, and it extends those same protections beyond sexual harassment, discrimination, and related claims. I know that there are some internal revenue code sections that also relate to settlement of sexual abuse and sexual harassment claims that I think you were going to mention, Peter.
Yes, particularly Internal Revenue Code section 162Q, if I recall properly. It's a very short and very poorly drafted piece of legislation, which basically provides that if in a sexual harassment case, if the settlement agreement contains a confidentiality clause, neither party can deduct their attorney's fees. And of course, this caused, there were some other problems with this legislation as well, but this was certainly primary. This caused a huge uproar. What came out of this was that in responses to frequently asked questions, the Internal Revenue Service has stated that this would not apply to the victim, the person who is receiving the funds. She could still deduct that under the code. However, the legislation has not been amended. And my only suggestion I can make to counsel is that if you're settling one of those cases, take a quick look at the Internal Revenue Service website to make sure that frequently asked question response is still valid, is still in effect, because the consequences could be very serious, obviously, from a tax perspective. It would eat up an awful lot of your settlement. Anything else, Judge Andler? Otherwise, I'll go on with some other confidentiality matters. Do you have anything?
Just CCP 1002 is worth
Yes.
looking at as well. And that is that if an attorney insists on such a provision and the underlying act is an act of child sexual abuse, child sexual exploitation, sexual abuse of an elder or dependent adult, or a sexual act that could be a felony, then the attorney who insists on the inclusion of language that prohibits the disclosure of the factual basis could be subject to state bar discipline.
Right, and that's important, assuming the state bar were to do anything about that, but we won't go there. That's my own editorial comment. I don't want to attribute that to anybody else. I should mention that both the CCP sections that Judge Andler mentioned are referenced in the materials that you should have received by now. Anything else, Judge Andler?
Nope, those are the points I wanted to make. Thank you.
Thank you very much. Just quickly on confidentiality generally, a couple of quick points. As I think everyone is aware, confidentiality is in mediation is very strict in California, and it's very broad and very extensive. This is discussed in the materials, but the relevant provisions begin at Evidence Code section 1115. I always say, if you are an attorney utilizing mediation, you should be familiar with the California Supreme Court decision entitled Cassell versus Superior Court. It's mentioned in the materials. I'll give you the site here because I think it's so important. It's 51 Cal 4th 113, 51 Cal 4th 113, California Supreme Court decision 10 or 11 years ago. I won't give you the facts now because we're kind of short on time, but it demonstrates how broad and extensive the mediation confidentiality is, to the point where it applies not only to the mediation proceeding itself, but also to conversations and discussions between counsel and client, not only in the mediation, but prior to the mediation. It's extremely broad. Well, I guess very briefly, Cassell involved a situation where a client sued his attorney for malpractice after the mediation, claiming that there were problems in the way the attorney conducted the mediation. In the malpractice suit, which became Cassell, the case known as Cassell, the Supreme Court said the client could not admit into evidence in the malpractice case anything that occurred at the mediation, nor discussions with his attorney. It was all subject to confidentiality requirements. It caused a lot of controversy for a while. And in the end, what came out of it was Evidence Code section 1129, which requires counsel, when a mediation is anticipated, as soon as that happens, to inform the client in writing, in a printed form, of the strict mediation confidentiality requirements, and requires counsel also to obtain a printed an acknowledgement by the client that they understand that is in printed form. And interestingly, the language that is suggested by the statute references the fact that if there is a subsequent malpractice action, evidence of what's said or done in the mediation and related matters, such as conversations with counsel, is not going to be admissible in the malpractice action, so that the client, I guess the theory was that the client wouldn't be blindsided by this evidentiary restriction if they later on. Very quickly, you should be aware, Judge Andler referred to mediations in Florida, and you should be aware, especially these days where we are in a global economy, that California mediation confidentiality requirements may not be enforced in other jurisdictions, even if the mediation was conducted in California. So if there's any possibility that you might need to seek enforcement elsewhere, be sure and advise your client of that. And my recommendation is you put that in the disclosure form that's required by section 1129 that we just discussed, advising the client of mediation confidentiality. Very quickly, I think everybody knows this, but to ensure that a mediation agreement is enforceable, at least in California, include the magic words in your settlement agreement. And it doesn't even have to be the exact words. The statute says words which say to the effect that the agreement is binding and enforceable or admissible and subject to disclosure. It's one sentence you put in your mediation settlement agreement that can save you an awful lot of grief if for some reason you seek to enforce the agreement. That's about all I have. Let me see if there are any. I thought there was a question.
There was. I answered it. They wanted the IRS section, so I typed it in there.
Oh boy, you are very efficient. Yeah, thank you very much.
The site for your last requirement about the magic words, if anybody's looking for that, look at Evidence Code section 1123. That's where you'll find the magic words. And then Evidence Code section 703.5 makes all of us incompetent to testify in any civil proceeding regarding any conduct at mediation. So if you've got one of those cases where you're trying to get a judge to approve a class action settlement to grant preliminary approval, and you say, well, would you mind filing a declaration with the judge? Can't do it.
No, I can't do it. One other thought on that subject. Some counsel like to use for enforceability CCP section 664.6. That section was amended effective either this year or last year. I think it was last year, to permit counsel to sign the and not the party necessarily to sign the agreement, and it can be enforced. However, there is no such permission, if that's the correct term, in Evidence Code section 1123. 1123 specifies that in a mediation settlement agreement, for it to be enforceable, in addition to the magic words, quote unquote, the parties must have signed the agreement. And there has been some litigation around that. But obviously the prudent course is not to leave anything to chance. I personally tend to think that 1123 is the way to go, simply because it is specifically addresses mediation settlements. And so you really can feel pretty comfortable if you adhere to those simple requirements of that provision and have your client sign it. It's always better practice anyway. And if there's a problem with that, okay, but normally there's not a problem. Now, let me see, there's a question in the Q&A, which I will read, and it says, in general, should mediation briefs be submitted in pleading format, or is there more of a trend now for briefs to be submitted in more casual ways by correspondence to the mediator? I have some thoughts on any of the panel members have some thoughts on
I
that?
have no preference. I just want the brief.
I want the brief. And I think the other thing is, the reason I want some time on the brief is to Eve's point. So if you look at that and somebody's saying, oh, but my hours are reduced, I don't necessarily expect the plaintiff to have that. But I will contact the defendant prior to the mediation and say, I want you to do an analysis of the time cards. If you're saying they weren't reduced to what he's saying, so I give homework in advance of the mediation when I get the briefs. I don't care how they're typed, as long as they're not in mouse script and with half a space in between.
I agree. I don't care about the form at all, as long as it's the content. We don't want to honor form over content. It's the content that counts. But what this illustrates, for me anyway, is the importance, and I think virtually everyone has spoken about this, the importance of speaking with the mediator ex parte prior to the mediation, because this is where some of those, for example, if you're concerned about the hours, and mediators we often are, because sometimes people show up without them. If you're concerned about that, the mediator can talk about that to counsel and say, come prepared to with some indication, some rough estimate at least of the hours, if you're talking about a wage and hour case. Anybody have any thoughts about that?
I think it's helpful to get a damages model in advance on the wage and hour cases. So that would be the one exception I have to a very informal brief. If you've got an expert that's worked up a damages model, I'd like to see it in advance.
Yeah, and again, as you indicated, I think everybody indicated beforehand, if you're going to bring experts or declarations or whatever, let the mediator know ahead of time. Sometimes there are very practical considerations, whether you're on Zoom or in in-person mediation. We are just about out of time. Any final comments? And before I forget, I want to thank all three of you panelists. This was really informative, and your comments were very thoughtful and helpful. And I think hopefully the audience will take away a lot of substance, actually. Any final comments?
One advisement, I guess. If you finished your mediation session and you don't have a settlement yet, and you are extending beyond 10 days, the efforts to try and have your mediation continue and result in a settlement, it's a good practice for counsel to confirm in writing that mediation confidentiality still applies and that the mediation is still open. Because if you don't, it may be deemed by one side to expire, and then the conversations may show up someplace you don't want them to show up.
That's invaluable. Excellent thought. All right, we have reached the end of our time. Again, thanks very much to all three of the panelists. your participation is very much appreciated. Thank you very much, and that ends our program. Good evening.
Good evening. Thank you.
Thank you.
Good night.
Good night.
Good night.